If you hold American citizenship or possess a green card and you are working to bring a relative to the United States, this video is made for you. And I need you to remain with me right through the finish because what I am going to reveal to you today could spare you months, potentially even years of pointless waiting, aggravation, and emotional pain. Family sponsorship immigration in the United States is among the most effective pathways available to reunite with loved ones. But it is equally one of the most widely misinterpreted systems in existence. Individuals commit the same preventable errors again and again, and in 2026, with revised regulations, tighter examination, and climbing financial benchmarks, the consequences have never been greater. So today, right here on US Updates Hub, we are going to unpack it completely, the essential rules, the refreshed requirements, and the most frequent blunders you absolutely need to dodge. Let us jump in. First, allow me to offer some foundation on what family sponsorship immigration truly involves, because not everybody watching this starts from the same knowledge base, and that is completely fine. When we discuss family-based immigration in the United States, we are referring to a legal channel that permits a U.S. citizen or a lawful permanent resident, meaning a green card holder, to petition for specific qualifying relatives to come and reside permanently in the United States. The cornerstone of this whole procedure is a document called Form I-130, which represents petition for alien relative. This is the paperwork that proves the qualifying connection between the individual already present and the family member overseas. Consider it as the opening domino in a lengthy sequence of actions. Everything else, the visa submission, the consular meeting, the green card, stems from that original petition. Now, not every family connection qualifies identically under U.S. immigration law. And this is a difference that bewilders many individuals. The law separates family-based immigration into two primary channels. The first channel encompasses what are known as immediate relatives of U.S. citizens. This covers a U.S. citizen's spouse, unmarried children below the age of 21, and parents as long as the U.S. citizen petitioner is no younger than 21 years old. Immediate relatives hold extraordinary advantage in this framework because they are not bound by yearly visa limitations. What that translates to in everyday language is that once the I-130 petition is granted for an immediate relative, there is no extended queue to endure merely for a visa number to open up. Processing still requires time, but the systemic congestion that burdens other groups simply does not exist here. The second channel is what we label the preference categories, and this is where matters become considerably more intricate. Family preference categories encompass relationships such as adult unmarried sons and daughters of U.S. citizens. That represents the F1 classification. Then there are spouses and children of green card holders in the F2A classification, and unmarried sons and daughters above 21 of green card holders in the F2B classification. In addition, married sons and daughters of U.S. citizens belong under F3, and brothers and sisters of adult U.S. citizens belong under the F4 classification. Now, every one of these preference categories is governed by yearly visa limitations established by Congress as verified by the Department of State's visa bulletins for fiscal year 2026. The fiscal year 2026 ceiling for family-sponsored preference immigrants is 226,000, and the per-country ceiling for preference immigrants is fixed at 7% of that overall annual ceiling, which calculates to roughly 25,620 per country, U.S. Department of State. This per-country restriction is why applicants born in nations such as Mexico, the Philippines, India, and China frequently encounter waiting periods that extend not merely years, but occasionally decades. Let me repeat that so it truly registers. For certain family preference categories in particular nations, the delay for a visa number to become accessible can reach 15 or more years. That is not an error. That is the truth of the existing system. And I share this not to dishearten you, but to assist you in grasping why beginning promptly, submitting accurately, and steering clear of errors is so vitally essential. Every setback you produce through a documentation mistake is time stacked on top of an already extended path. So let us discuss what is precisely occurring in 2026, because there are genuine and substantial developments that every family petitioner must understand right now. U.S. Citizenship and Immigration Services has released refreshed policy direction in the USCIS policy manual to strengthen the agency's ability to evaluate and examine family-based immigrant visa petitions. This revision explains eligibility standards, submission, interviews, and the agency's adjudication procedure. Critically, USCIS has announced that it is emphasizing thorough evaluation and examination to safeguard national security and has specified that it may issue a notice to appear if the alien beneficiary is otherwise deportable, since an approved family-based petition does not independently confer immigration status or protection from removal. USCIS. This is a meaningful explanation that numerous individuals disregard. Approval of the I-130 petition is a phase in the journey. It is not the finish line. Beginning in 2026, USCIS is rolling out modifications designed at enhancing petition procedure effectiveness and safety, including tighter documentation submission standards and advanced biometric information gathering methods. Vasquez Law Firm. What this signifies in practical terms is that you must deliver your strongest effort when you submit. Presenting a deficient, partial, or carelessly assembled petition in 2026 is going to damage you more than it would have in earlier years. USCIS is sending out more requests for evidence on family petitions than in preceding years, especially for spousal applications, which indicates thorough, properly documented original submissions are more critical than ever. Law Office Immigration. Now, one of the most impactful practical developments for 2026 concerns the financial sponsorship obligations. Every family petitioner in the United States is obligated to submit what is known as Form I-864, the Affidavit of Support. This is a legally enforceable agreement between you and the U.S. government in which you pledge to economically sustain your family member and guarantee they do not become a so-called public charge, referring to someone who depends on government benefits. The earnings benchmarks for this form are refreshed each year according to the federal poverty standards, and 2026 has delivered raises across every level. For a household of two, like a U.S. citizen petitioning for a spouse, a single child, or one parent, the mandatory minimum earnings has climbed to $27,150. For a family of four, petitioners must now show an income of $41,250. For a family of 8, the figure rises to $69,650. And for every extra individual after that, the benchmark grows by $700, NOLO. If your earnings do not reach these benchmarks, you are not instantly eliminated, but you will require what is termed a joint sponsor, a different U.S. citizen or green card holder who satisfies the financial standards and is prepared to co-sign the Affidavit of Support. Ensure that individual comprehends they are accepting a genuine legal commitment. Let us now shift to the blunders. And I want to be extremely straightforward here, because these are actual errors that actual families commit every single day, and they rob people of months of their lives. USCIS turns down thousands of petitions annually for fundamental errors, unsigned documents, absent filing fees, wrong versions of forms, or neglecting to attach mandatory supporting materials. Law Office Immigration. The absolute first action you should complete before you send anything is visit the official USCIS website, uscis.gov, and verify you are utilizing the most recent edition of Form I-130. Forms receive revisions, and filing an expired version is an instant setback. Inspect the addition date in the bottom left area of the form. The second significant blunder involves contradictory information. USCIS demands your petition, accompanying documents, and any interview answers to correspond uniformly. Inconsistencies like mismatched dates, clashing addresses, or opposing statements can lead officials to question the legitimacy of your case. Even genuine oversights may be read as dishonesty. Citizen path. So review every individual document you are filing with extreme precision. Verify that names are written identically across all papers. Verify that birth dates correspond. Verify that addresses are uniform. These minor particulars carry tremendous significance. The third blunder, and this one is notably frequent for spousal petitions, is not supplying sufficient proof of an authentic relationship. Numerous couples get refused because they depend solely on marriage documents. Without shared accounts, combined leases, or everyday life documentation, USCIS may reject the petition even if the relationship is legitimate. Cheeto law. Reflect on what records you can assemble that demonstrate a combined existence. Shared bank account records, rental agreements bearing both names, household bills, photographs together spanning time, travel documentation, messages and correspondence, sworn statements from companions and relatives who recognize you as a couple. The more detailed and comprehensive your documentation, the more assured USCIS will be that this is a legitimate relationship and not a marriage arranged for immigration purposes. The fourth blunder is arguably the most procedurally destructive, neglecting to answer a request for evidence or RFE in a prompt and thorough fashion. An RFE is not a rejection. It is USCIS requesting you for additional details, but how you answer it will decide whether your case advances or falls apart. You must answer within the time frame, usually 30 to 87 days, and then USCIS must evaluate your answer. An insufficient or tardy RFE answer can append 3 to 6 months or longer to your processing duration, and neglecting to answer entirely can produce a rejection. Alonzo and Alonzo. So if you obtain an RFE, halt what you are doing. Study it thoroughly, collect precisely what is being requested, and answer as fully and rapidly as you possibly can. The fifth blunder involves not comprehending the gap between your I-130 approval and visa accessibility. This perplexes families perpetually. For family preference categories, I-130 approval does not signify a visa is instantly accessible. Applicants must hold on until their priority date turns current under the visa bulletin. In certain categories and nations, this hold can persist many years. NPZ Law Group. Your priority date is fundamentally the date your petition was submitted. It operates like a position in queue. Every month, the Department of State issues the Visa Bulletin, which informs you which priority dates are presently being processed. You can only advance with the subsequent phases of your case. Actions like submitting for the immigrant visa or adjusting status once your priority date is current. Reviewing the Visa Bulletin every single month is not discretionary, it is mandatory. Save travel.state.gov immediately if you have not done so. A sixth blunder that is growing progressively more consequential in 2026 is not being equipped for your biometric session or your immigration interview. USCIS is now stressing advanced biometric information gathering methods as part of its 2026 revisions. Vasquez Law Firm. When you obtain a biometric session notification, show up on schedule and carry the necessary documents. Skipping a biometric session without legitimate reason can cause your case to be deemed abandoned. Regarding interviews, whether at a USCIS field office or at a U.S. consulate overseas, readiness is everything. USCIS officers are educated to detect discrepancies in how couples and relatives portray their connection. In 2026, anticipate sustained emphasis on demonstrating that your family bond is authentic. This pertains not only to marriage-based petitions, but additionally to parent-child and sibling sponsorships, with officers examining paperwork meticulously to confirm precision and coherence. Altius Law. Let me additionally address briefly green card holders who are in the midst of sponsoring a spouse. This is a circumstance where naturalization can produce a genuinely remarkable difference. If you are a green card holder sponsoring your spouse and you obtain U.S. citizenship, your spouse transitions from the F2A classification, which involves a 2 to 3 year hold, to the immediate relative classification, which carries no yearly visa restriction and no priority date congestion. This singular action can conserve years. Law Office Immigration. If you are qualified to seek naturalization, it is worthwhile having a thoughtful discussion with a skilled immigration attorney about whether that direction is appropriate in your particular circumstances. Now let us examine what you can accomplish right now today to position yourself in the most favorable condition achievable. First, retrieve all the records you possess connected to your family sponsorship case and arrange them. Create electronic duplicates and preserve them safely. Second, if you have previously submitted an I-130, access your USCIS profile at USCIS.gov and review your case progress using your receipt number. Confirm you have enrolled for email or text alerts so you never overlook an update. Third, navigate to travel.state.gov and save the visa bulletin page. Create a monthly calendar notification to review it. Fourth, if you are nearing the financial benchmark for the Affidavit of Support, compile your most recent tax filings, pay statements, and any additional proof of earnings or assets now before you require them. Fifth, if you obtain any notification from USCIS, whether it is an RFE, a biometric session, or an interview notification, answer swiftly and thoroughly. Do not postpone. And perhaps most critically, if your case is complicated, if there are previous immigration infractions, criminal background, earlier marriages, adoptions, step connections, or anything that does not align smoothly with the typical scenario, please seek advice from a qualified immigration attorney before you submit anything. The expense of making errors is considerably greater than the expense of obtaining professional direction beforehand. Immigration attorneys cannot promise results, but they can assist you in preventing the avoidable mistakes that derail so many applications. Before I conclude, I want to state something very plainly. As I consistently do on this platform, everything you have received today is informational in character. It is not legal counsel. Immigration policy can and does shift, sometimes swiftly, sometimes drastically. The information I have provided to you is grounded in official sources, including USCIS, the Department of State's Visa Bulletin, and present policy direction, precise as of April 12, 2026. But your personal situation is distinct, and no video, regardless of how comprehensive, can replace individualized professional direction. Always confirm the most current standards at uscis.gov and travel.state.gov. And for your particular case, please engage a licensed immigration attorney or accredited representative. I want to express something to everyone who is navigating this journey right now. I understand how difficult this is. I understand what it signifies to have someone you cherish, a spouse, a parent, a child on the opposite side of an ocean waiting. The immigration system is not simple. It is not consistently equitable, but it is manageable. And understanding is your most formidable resource. That is precisely why US Updates Hub exists, to deliver clear, precise, dependable information so that you can render informed choices and champion your family with assurance. If this video assisted you today, please take an instant to give it a thumbs up. That straightforward gesture tells us that this material is creating an impact, and it assists other families in locating this information when they require it most. Forward this video to someone you know who is experiencing the family sponsorship journey, because the individual beside them might be committing one of the errors we examined today, and this video could transform everything for them. Subscribe to US Updates Hub if you have not previously, and activate the notification bell so you never skip an update. We address developments in U.S. immigration law on a consistent basis, from USCIS policy modifications to visa bulletin revisions to actionable guidance for every phase of the procedure. Review the description beneath this video for connections to official USCIS materials, the Department of State's visa bulletin page, and direction on locating a qualified immigration professional. Thank you tremendously for being present. Your family's narrative matters, your path matters, and we are present every phase of the journey to assist you in steering through it. Until the following time, stay knowledgeable, stay equipped, and look after yourselves and the individuals you cherish.